Good morning. Thank you very much for having invited me to this seminar in Tirona. This is a brilliant seminar. I'm sorry, but this will be it in Spanish.
And it's my very great pleasure to introduce as our first speaker this morning, Professor Bruno Celano. Professor Celano is currently Professor of the Philosophy of Law at the University of Palermo. He's well known for his important and wide-ranging work in philosophy and in philosophy of law on a variety of topics, including the legal theory of Hans Kelsen and in the philosophy of practical reason. This morning, he is going to present to us his paper on normative legal positivism, neutrality, and the rule of law, an incredibly rich and nuanced paper in which he discusses various connections between a certain way of conceiving of a certain form of normative legal positivism, the ethico-political ideal expressed by the rule of law, and certain kinds of what he regards as valuable neutrality in law. Professor Celano will present his paper for about 45 minutes, and then I'll invite discussion from the floor of the conference. Without further ado then, I welcome and hand over to Professor Celano.
Thank you very much. First of all, I wish to thank the organizers of this conference and Julie Dixon for her kind words. So, I read a synthesis of my paper, which is actually very long, and this is much shorter, in fact. Usually, in jurisprudential debates, what is discussed under the heading of neutrality is the claim that jurisprudence is, or at least can and should be, a conceptual or descriptive or non-normative or morally neutral inquiry. I shall discuss neutrality in an altogether different sense, namely neutrality as an ethico-political value. Mine will be an essay in legal theory as a substantive normative inquiry, pursuing neutrality as an ethico-political ideal the law should meet. My starting point is normative legal positivism. What justifies normative legal positivism, I shall claim, is the value or the ideal of neutrality, suitably understood. That is, what is desirable about laws being such as normative legal positivism claims they ought to be, is in a sense to be specified their neutrality, law's neutrality. What then is the relevant concept of neutrality? And why is neutrality so understood a value? Answers to these questions, I shall argue, can be found if we turn our attention to the idea of the rule of law. Normative legal positivism, I shall claim, envisages neutrality through the rule of law. There are two connections. The first is through stability of mutual expectations. The second stems from what I will call the inherent neutrality of prescriptions. Under both respects, it turns out, I quote from Joseph Ross, observance of the rule of law is necessary if the law is to respect human dignity. My understanding of normative legal positivism is very thin. By normative legal positivism, I mean, paraphrasing Waldron, the claim that the separation of law and morality, that is, the separation of the grounds of legal judgment and the grounds of moral judgment, is a good thing, something to be valued and encouraged. I distinguish two versions of normative legal positivism, an epistemic and a substantive one. Substantive normative legal positivism claims that there are sound moral reasons, why the law should reproduce and enforce only a very limited portion of the content of morality. In its epistemic version, on the other hand, normative legal positivism says that it is desirable that laws should be identifiable as such and their content capable of being determined on the basis of, so far as possible, easily accessible, readily identifiable and non-controversial social facts or sources, independently of moral or other evaluative considerations. This claim echoes Joseph Raz's sources thesis. It is, however, a different claim. Raz's thesis is meant as a claim about what the law is. The main claim of epistemic normative legal positivism, we might dub it the normative sources thesis, is, on the contrary, a claim about what the law ought to be. It says, roughly, that it is desirable that the laws be such as Raz's sources thesis claims them to be. I will say that when it meets this desideratum, the law satisfies the sources thesis. This should be understood as a term of art. I shall be concerned with the epistemic version of normative legal positivism only. From now on, in talking of normative legal positivism, it is to this version of normative legal positivism that I shall make reference. Normative legal positivism, then, claims that it is desirable that the existence and content of the laws satisfy the sources thesis. But we should ask, what can be desirable about laws satisfying the sources thesis? One possible answer is this. If the law is to have legitimate authority, it must be like that. Or in short, the law should have legitimate authority. For it to have legitimate authority, it is a necessary condition that it satisfies the sources thesis. Thus, the law should satisfy the sources thesis. Now, whatever the merits of this argument, in what follows, I shall explore an altogether different line of argument, namely the following: that the law be separated from morality, that the existence and content of the laws may be determined on the basis of easily identifiable, readily accessible, uncontroversial social facts. This is desirable because when it satisfies this condition, law is, in a sense to be specified, neutral. In which sense, then? And what is of value in neutrality, so understood? To answer these questions, we have to turn to the rule of law. By the rule of law, I mean, as is usual in contemporary jurisprudence, a loose cluster of, first, formal features of the laws, namely prospectivity, publicity, relative generality, relative stability, intelligibility and relative clarity, practicability, namely conformity to the principle ought implies can, and finally consistency. Plus, 2, some institutional and procedural desiderata, such as, for instance, that the making of singular norms be guided by general rules and the so-called principles of natural justice. Now, most of these features specify what is instrumentally required in order to achieve an end, namely the end of guiding human behavior through rules. In other words, they are features the laws must possess if they are to be capable of being followed and obeyed. So understood, the features constituting the rule of law are features an instrument, namely laws, must possess in order to perform its function, guiding human behavior, and to perform it well. In Raz's famous analogy, rule of law requirements are analogous to the sharpness of a knife. Normative legal positivism, I shall now argue, envisages neutrality through the rule of law in two ways. Here's the first. Consider the following train of thought. I shall call this the common measure myth. It goes like this. By virtue of their satisfying the sources thesis, some standards of behavior are singled out as unique in being the rules of the group as a whole. Different individuals or different groups may have different views about what course of action to settle on in case of a felt need for a common decision. Laws satisfying the sources thesis, so the story goes, settle these uncertainties, thus resolving such quandaries. The many private judgments of individuals and groups are replaced by a source-based, in principle readily accessible, common measure, a single public judgment counting as the judgment of the group, or as its public reason, or as the public reason of the community, supplanting the many conflicting private reasons of individuals. Now, this is, as it stands, a myth. The mere fact that a directive is enacted as source-based law by itself does not solve disagreements, nor does it create a common measure expressing a purported public judgment of the group as a whole. Talk of such directives as the public reason of the community does not contribute to clarity. There is, however, a grain of truth in the common measure myth. Directives enacted as source-based law are, in a sense, neutral, and this is, ceteris paribus, something valuable about them. Why? In which sense? Because, in short, laws satisfying the sources thesis may work as neutral social interaction devices, in that they may become the common focus for stable mutual expectations. Now, this may happen in two ways. First, laws may afford the solution of coordination problems proper. I mean, coordination problems in the strict game theoretical sense. Being singled out by law-making institutions, one equilibrium becomes salient and the parties converge on it. Neutrality here is indifference. By hypothesis, it is almost indifferent to the parties which, among the many equilibria available, will be the chosen one. In such cases, laws do indeed qualify as a common measure. The common measure myth is, in fact, no myth at all. These are, however, marginal cases of very limited import. Critical interaction problems are not coordination problems in this strict sense. In the case of strategic interaction problems of different, more intractable kinds, problems like battles of the sexes, prisoners' dilemmas, problems of collective action of various sorts, or in the case of many real-world deep disagreements and conflicts, in most of these cases, the common measure myth is indeed a myth. in these cases, talk of legal directives as such as a common measure is mere rhetoric. In such cases too, however, directives enacted as source-based laws may afford stability of mutual expectations. It is common knowledge that probably people will comply with them, and this allows each of the parties to form expectations about how the others will act, on the basis of expectations about how the others will expect him to act, and so on. Interlocking mutual expectations of this sort will enable individuals to make reasoned choices and to plan their future. And it is here, I think, that the rule of law comes into play. Rule of law requirements define an ethico-political ideal. It is one political ideal among many, not to be confused with any one of them. It is, moreover, a modest ideal, not in the sense that it is easily attainable, but in the sense that it is compatible with gross injustice, and in general with gross violations of other ideals. But however modest, the ideal defined by rule of law requirements is crucially important in the present connection, for the following reason. Apparently, we could argue this way. Source-based laws generally tend to afford stability of mutual expectations. Stability of mutual expectations, however, is most firmly secured where rule of law requirements are met. Therefore, the relevant sort of neutrality is most firmly secured where the laws, apart from satisfying the source's thesis, also satisfy rule of law requirements. The connection, however, is even tighter than that. When we find ourselves inclined to say that source-based law generally tends to afford stability of mutual expectations, it is in fact source-based law meeting, to some degree at least, some of the rule of law requirements that we are thinking of. It is laws that satisfy the source's thesis and also meet, at least to a minimal degree, some of the rule of law requirements: prospectivity, intelligibility, publicity, relative generality, regular application by unbiased judges. It is laws like that that work as neutral social interaction devices, affording stability of mutual expectations. And where rule of law requirements are met, we can clearly see, I think, what is valuable in stable mutual expectations. Rule of law requirements imply that the expectations the law will give rise to will be, insofar as the law itself is concerned, will be reliable expectations. The law will not work as an entrapment. The word is rasis, as an entrapment device, encouraging expectations that it will afterwards frustrate. Laws meeting rule of law requirements will, in sum, give rise to a stable, reliable system of mutual expectations, of interlocking mutual expectations, thus guaranteeing a measure of trustworthiness, fairness, and reciprocity in the interaction of rulers and ruled, and of laws subjects with each other. This, I submit, is a form of neutrality. Neutrality as fairness. I now come to the second connection between normative legal positivism and neutrality via the rule of law. This connection concerns a particular version of the rule of law, a version which, very roughly, was developed in European legal culture in the 18th and 19th centuries. In this understanding, what is central to the rule of law is the activity of legislating, that is, the issuing of prescriptions. Prescribing is a kind of purposive human activity, roughly trying to make people do something by telling them to do it. The activity of prescribing, in its standard cases, has many formal features. As with any other purposive activity, some of these features express the requirements that the activity has to meet in order to achieve, and to achieve well, its constitutive purpose. And some of these features aptly instantiate elements of the rule of law ideal. So, for instance, in order to achieve their intended purpose, prescriptions typically have to be prospective and intelligible. Further, the activity of prescribing is subject to rational pressure in favor of conformity to the principle ought implies can, practicability, and to the avoidance of conflicts, consistency. Now, this legislative twist to the rule of law should not be surprising. After all, most of the requirements of the rule of law follow, as I have said, from what is instrumentally required when we want to subject human behavior to the guidance of rules. And of course, prescribing just is, in a straightforward sense, trying to subject human behavior to the guidance of rules. True, prescribing is not necessarily the issuing of general directives or of rules proper. Under this respect, the requirements of the rule of law do not apply to prescribing as such. But let us abstract from this and focus our attention on the respects in which prescribing does indeed instantiate the kind of activity rule of law requirements apply to. When we see things in this light, a particular version of the rule of law emerges, comprising what is involved in a particular method of social control, which consists primarily of the issuing of directives, namely of in the issuing of prescriptions, namely of directives communicated to persons who are then expected to understand and conform to these directives. Henceforth, I shall call this version of the rule of law Enlightenment rule of law, due to its embodying some more or less utopian, eminently rationalistic, as we shall see in a minute, and perhaps simplistic desiderata. Laws meeting the rule of law requirements may have almost any content, but I suggest what is peculiar as regards the rule of law is the form that the exercise of power takes. Now, it is certainly not unusual to characterize the rule of law as a specific form or mode of the exercise of power. When it is so characterized, the rule of law is usually contrasted with managerial governance, or it is contrasted with arbitrary power, meaning by this public power wielded in the pursuit of private interests. Now, these contrasts are not mistaken, of course, but I suggest, in order to understand what is peculiar to the rule of law and specifically to Enlightenment rule of law, and to see what is neutral about it, we have to widen the scope of the comparison. We have to contrast the rule of law and specifically Enlightenment rule of law with other modes of the exercise of power, modes that are by no means rare or bizarre, but often go unnoticed in these debates. Power exercised by telling people to behave in the desired ways, thus power exercised by issuing laws meeting Enlightenment rule of law requirements, has to be distinguished from power exercised through different means or through linguistic means used differently. Thus, it has to be distinguished from symbolic, charismatic, and pastoral power, from power exercised through manipulation, indoctrination, propaganda, or by various forms of deceit. And finally, it has to be distinguished from persecution, disciplinary power, mute punishment, and sheer physical intervention. What distinguishes it from these forms of power is the combination of two features. First, it is rational. Second, it is public, transparent, out in the open. Let me now try to explain this. When the government treated subjects in accordance with Enlightenment rule of law, it treats them as adults capable of making their own decisions on the basis of their own preferences and their own understanding of the relevant facts. It tells them explicitly, I want you to behave in such and such a way. This will be the consequences in case you don't. Now it's up to you. Let us contrast this mode of exercising power with the way in which children are often treated. In order to make children do what we want them to do, we sometimes tell them lies. Candy shops are closed now. We fake non-existing unpleasant consequences. The wolf will come and get you. In various ways, we distort reality, or we try, unknown to them, directly to manipulate the environment or their preferences by working behind their back, so to speak. Or again, we rely on an aura of parental authority or on symbols. In acting in these ways, we do not recognize children the dignity of responsible agents capable of autonomous choice. Let us now try to spell out what is involved in this contrast. We are considering a simple situation. X issues a prescription addressed to Y. For instance, X orders Y to do something, and his order is backed by the threat of an unpleasant consequence in case of non-compliance. The latter is what Hart famously referred to as the gammon situation. I shall use this label here because I think it is important to stress in the present context that it is also this kind of situation that I am focusing on. But it should be remembered throughout that the gammon situation is only one among different kinds of prescriptive relationships. What I'm interested in is generally, albeit with some qualifications spelled out in the paper, is generally the mode of power exercised in trying to make somebody do something by telling her to do it. So, the Gamma situation has two basic features, and I stress this. These are features that prescriptions standardly or typically exhibit, and defeasible presumptions. Non-standard prescriptions are possible, of course, and these will be cases of abuse of the institution of prescribing. So, two features. The Gamma situation has two features. First, it relies on the rational agency of the parties, and second, it is fully public. First feature, rationality. The Gamma situation is conspicuously a form of rational interaction, that is, a kind of situation, an adequate description of which is premised on the assumption that the parties involved possess and exercise distinctively rational abilities and skills. True, in the Gamma situation, X exerts a kind of causal influence over Y. But contrary to what happens in cases, for instance, of sheer physical force or of straightforward manipulation of the agent's preferences, in the Gamma situation, the influence being exerted on the subject's behavior depends on the exercise on the part of the subject herself of complex rational skills. The subject is presumed by the Gamma to be a rational agent. Rationality here designates in the first instance the ability to understand the utterance of a sentence, to grasp its meaning and force. This includes, of course, the mastery of concepts. Moreover, the workings of an order backed by a threat rest on a complex set of interrelated intention and their successful expression and detection. Typically, the lawgiver has first the intention to make the addressee perform a certain action. Second, he intends to make her perform the action as a consequence of his uttering a sentence. And third, he intends to make her perform the action as a consequence of his uttering a sentence by virtue of the recognition by the addressee herself of these very same intentions. Thus, the addressee is presumed to be capable of understanding, first, that the speaker wants her to behave in a certain way, second, that he wants to make her behave in that way, third, that he wants to produce this outcome as a consequence of his uttering a sentence, and fourth, that he wants to produce this outcome by virtue of her recognition of this whole set of intention, 1 to 4. Thus, for a prescription to affect the addressee's conduct in the way it is intended to, it is necessary that the addressee understand that her understanding of the prescription, this very understanding, is a necessary condition for it to produce the desired outcome. As a consequence, the influence exerted by the lawgiver on the addressee may be said to be a kind of causal cum rational influence. In order for the addressee's conduct to be affected in the desired way, she has to understand that it is being affected in this way. A prescription, that is a kind of tool that works in the way it is intended to work only if the object it causally affects, understands that it is so working. But how can understanding and utterance of the relevant sort lead an individual to act in a given way? If Y understands the order and the threat, it may happen that she decides, on the basis of her desire to avoid the unpleasant consequence, to do what X ordered her to do. This illustrates a further sense in which the influence a prescription produces is a kind of causal cum rational influence. The influence exerted depends on and is grounded in a piece of reasoning on the addressee's part. For instance, unless I do A, I shall incur in sanction S. I do not want to incur in S. Thus, I ought to do A. Sorry. Second feature, common knowledge. The mode of power we are discussing is a kind of power whose exercise takes place out in the open between lawgiver and addressee, in the following sense. In prescribing, the lawgiver intends to make the addressee perform a given action by virtue of her recognition, by the addressee herself of this very same intention. Thus, an utterance counts as a prescription only if the addressee believes that the lawgiver has the relevant intentional structure. If she believes the lawgiver to believe that she believes he has it, and so on. Likewise, it is necessary that the lawgiver believes that the addressee recognizes this structure, that he believes her to believe that he believes this, and so on. In short, a prescription only has been issued if a suitable system of interlocking mutual beliefs comes into play, only if it is common or mutual knowledge between lawgiver and addressee that it has been issued. And this, by the way, is how we should understand, I suggest, what is involved in the rule of law requirement of publicity. Thus, the mode of power exercised in making somebody do something by telling her to do it relies on the rational agency of the parties and is fully public. Now, when power is exercised in this way, then thus, when enlightenment rule of law requirements are met, I suggest a kind of neutrality is achieved. Law-giving neutralizes some of the difference between lawgiver and addressee, leveling in a sense their respective positions. By this, I mean two things. First, lawgiver and addressee are put in a position of reciprocity. They interact as rational agents in the light of an appropriate set of mutual beliefs concerning inter alia their status as rational agents. To this very limited, of course, extent, their respective positions are leveled. They face each other as equally engaged in communicating with each other. Second, the subject to whom a prescription is addressed is kept at a distance, so to speak. She is not regarded by the lawgiver as an extension of his own body or as merely a tool. Causal efficacy on her conduct is mediated by her own understanding of its being exerted and how, and this is common knowledge between the two. Now, all this, of course, may look overstated. Orders backed by threats are sometimes harsh, brutal. They may be addressed by a master to his slave. The operation of requests may rest on sweeping forces and all too powerful incentives. Some offers simply cannot be refused. The two features I listed, however, concern the form or structure of the relationship, at least when conditions are met designed to exclude offers that cannot be refused. When we contrast the issuing of a prescription with recourse to sheer physical force or to silent manipulation of the subject's environment, I think we can see this twofold difference. Law-giving thus, in a sense, neutralizes asymmetries between lawgiver and addressee, leveling their positions. Prescriptions are, in this sense, inherently neutral devices for the exercise of power. This is not, of course, substantive neutrality, not taking sides in favor of any particular subject or group of them. As far as their content is concerned, laws meeting Enlightenment rule of law conditions have, as such, nothing neutral in them. What I have called the inherent neutrality of prescriptions concerns their form, that is, the kind of communicative attitude involved in their workings. Prescriptions satisfying the sources thesis will egregiously exemplify this model. In fact, prescriptions as such are typically source-based. Directives enacted as prescriptions as such, typically satisfy the source's thesis. But does this kind of neutralization have anything of value in it? Once again, the rule of law, and specifically Enlightenment rule of law, is a modest idea. It is compatible with violations of other ideals. But when we consider the inherent neutrality of prescriptions, we see that there is something valuable in Enlightenment rule of law. When the government treats its subjects in accordance with Enlightenment rule of law, it treats them, as we have seen, as rational agents capable of finding their way in complex structures of communicative intentions and of making their own decisions on the basis of their own preferences and their own view of the relevant facts. By treating them in this way, government recognizes them the dignity of responsible autonomous agents, worthy of being publicly, openly addressed, and of being guided through their own understanding of the way in which power is being exerted on them. In short, it treats them with, and shows them, respect. This way of exercising power, I said, is very different from the way in which people sometimes try to guide children's behavior, distorting reality or trying to manipulate the environment or their preferences by working behind their back, relying on the efficacy of symbols or charisma. These, of course, are ways in which even adult men and women are often treated, and sometimes wish to be treated or have to be treated. But they are not, I submit, respectful ways. So individuals are, to the extent that they are all addressed as the addressees of prescriptions, they are all treated with equal respect. This is compatible with all sorts of unjust discrimination, of course, but it positively is, it seems to me, a valuable feature of laws satisfying the source's thesis and meeting Enlightenment rule of law desiderata. My conclusion, then, is that if you have some sense that the law ought to be neutral, and if you are looking for a way of giving a definite, respectable meaning to this distressingly vague, generic thought, then you have good reason for claiming that the law should satisfy the source's thesis and conform to Enlightenment rule of law requirements. You have good reason then for endorsing normative legal positivism. I have tried to flesh out this claim by explaining some of the ways in which the idea that the law ought to be neutral can sensibly be understood, and correspondingly to explain why conformity to the rule of law, and specifically to Enlightenment rule of law and to the source's thesis, warrants neutrality in the relevant sense or senses. Laws satisfying the source's thesis and meeting rule of law desiderata may achieve neutrality as indifference in the case of coordination problems proper, and neutrality as fairness via reliability of mutual expectations in the case of disagreements where conflict is serious. Further, laws meeting Enlightenment rule of law desiderata may achieve, via the inherent neutrality of prescriptions, neutrality as equal respect. In Enlightenment rule of law, these two perspectives combine. The first connection combines with the second, where the law satisfies the source's thesis and meets Enlightenment rule of law requirements, fairness and respect for persons are instantiated in the very structure of the law itself. Or, to quote once again Joseph Raz's words, observance of the rule of law is necessary if the law is to respect human dignity. Thank you very much.
Thank you, Professor Celano, for that very clear presentation of your position. I'd now like to invite questions from the floor of the conference. We have about 45 minutes for discussion. Please be patient with me if I don't see you at first. And can I ask that for this session that all speakers, all questioners stand up? It will help us to see you better. So. Okay, we're going to start with the gentleman about 5 rows back on the end. Yes, thank you.
Thank you. Bruno, one thing I miss in your paper is some mention to democracy, because as you know, many authors link the idea of rule of law with democracy, especially if, as your analysis emphasizes the idea of equalizing the lawgiver with the addressee or with the subject to the law. Well, I wonder, many people think that this treating the subjects to the law with dignity, respecting their autonomy, requires to make them co-authors of the law. And this idea of distinguishing the mastery of the domination that the gunman can exert on the victim maybe would require that the prescriptive activity or the law-giving activity neutralizes this domination in the idea that democracy offers. So, and especially considering that some normative positivists like Waldron or Campbell have made this connection between rule of law and democracy, which is a connection from your point of view.
Okay, thank you very much for this question. And well, the rule of law, as I understand it, is a very modest ideal. It has to be distinguished from other respectable ideals: justice, human rights, equality, and democracy. And it is compatible with violations of these further ideals. So when I say that prescriptions are inherently neutral, and so enlightenment neutral rule of law requirements, the satisfaction of enlightenment rule of law requirements in a sense neutralizes some differences between lawgiver and addressee, I am referring to some kind of minimal neutralization, the kind of neutralization of differences which is involved in a master's addressing to his slave a command, a prescription. This is not, of course, full equality, and the kind of respect involved in taking this communicative attitude is certainly not full respect toward a person as we may think it is desirable, but it is minimal respect. The kind of respect involved in taking this communicative attitude is minimal respect. It is a kind of respect. If you contrast this way of trying to make people do something with other modes, for instance, sheer physical force or working behind the back of other people in order to manipulate the environment or their preferences, or with propaganda. When you contrast this way of exercising power with when you contrast the issuing of prescriptions with these further ways of exercising power, or for instance mute punishment, as Bentham said, dog law, just beating, hitting the dog, giving it a kick, kicking it when it does something we do not, something unpleasant to us. When you contrast the issuing of prescriptions with all these further kinds of modes of exercising power, then I think we can see that there is some respect for persons involved in telling them to do something. Yes. So I'm sorry. But this is not respect in a full sense. This is not the fulfillment of the highest ideal we might cultivate. It has nothing by itself to do with democracy. The rule of law, I repeat, as I understand it, as a set of formal plus institutional desiderata, the ones I listed summarily in my presentation and are listed in detail in my paper, the rule of law has consisting in this, so understood, is not democracy, is compatible with the violation of democracy. I know that many of the defenders of normative legal positivism are defenders of democracy, but my version of normative legal positivism is very thin, is skeletal. It boils down to the claim that it would be desirable that the laws satisfy the source's thesis. That's all. Thank you.
Thank you. We already have 7 people on the queue, and the next question will come from Professor Alexi.
Yes, thank you. Well, I think that normative positivism is a kind of self-destructive form of positivism. Kelsen was very clear about this point, that you should not have any values at the basis of law. Therefore, we have the whole story of the Grundnorm, the basic norm. For if you start with values as reasons for positivism, as you say, as reasons for the source's thesis, then why only weak values? Why only weak or soft values? Why only a minimum of respect? If respect and equality at all, as you told us, is a value, all values tend to require an optimization or even a maximization. Therefore, I think then if you start with equal respect, as you say, you talk about the dignity, the strongest word in moral philosophy, one of the strongest, the human dignity. Everything you can combine with this. If you start with dignity, why do you stop at this level? Therefore, I would have 2 theses. The first one is, in normative positivism, there is a tendency of non-positivism because these values try to expand. If, my second point, the first point is normative positivism has a tendency to non-positivism. That is the first point, an inherent tendency, necessarily. And my second point is, if you want to keep normative positivism as a kind of positivism, then your paper is not the whole story. You need a second part which concerns normative arguments against other values. You must deliver a theory, why not more than a minimum? You must make a normative argument against optimization or maximization. And you must have a normative argument against democracy, as included in the concept of law, against human rights, as included into law. And I completely agree with you that the positive values of the sources thesis and the rule of law, especially the enlightened rule of law, completely true. Completely true. But that is not the decisive point to show that the rule of law has some value, or even the enlightened rule. Many people, I think all, will agree with you. The decisive question is to stop. Why to make a stop at this point? Why to exclude all the other things? And that's my point.
Thank you very much for this question. This gives me the opportunity to state here something which is a point which is in fact stated in the paper, explicitly stated in the paper, namely that I actually, I do not care much about the label positivism. Normative, whether you wish to call my position, this position, the normative source thesis, whether you wish to call it positivism or not, it's not important for me. You may have it both ways. It's not really a point which makes a difference for me. This is explicitly stated in the paper. And, well, about the second question, why stop at a minimum? Well, I do not want to exclude, so to speak. I mean, I have nothing against human rights or democracy or stronger forms of respect for human dignity. This is not a paper about the highest good. This is a paper about a minimum level, but a level indeed, which I think has to be distinguished from further levels, further layers, which may be involved in an ideal of legal order for a political community. This is only a tentative analysis of one layer which is there and can be distinguished from the other layers without implying that the other layers are not there, cannot be, in a sense, that it cannot be argued, that we cannot argue for them. Just a layer which can be distinguished and analyzed in its own right. What I said, quoting Raz, is not that the rule of law so understood or Enlightenment rule of law is sufficient for respecting human dignity. Only that it is necessary, that respect for Enlightenment rule of law requirements, as I understand the rule of law, is only a necessary condition. You may say necessary conditions are not sufficient. This is true. Necessary conditions are not sufficient conditions. A minimum of goodness is not the highest good. But my paper is only about a necessary condition, a phenomenon which can be distinguished from other phenomena, an ideal which can be distinguished from other ideals, and which can be analyzed, understood, and argued for in its own right.
Thank you. Next we have the gentleman in the third row back on the right. That's correct.
Thank you very much. I think that this is a very nice way to put the question of the rule of law. But you say, Bruno, that normative legal positivism claims that it is a good and desirable thing that laws satisfy the social thesis. Well, however, as you acknowledges in the paper, this claim is not absolute. Well, my question is, if you agree that this claim is compatible with the presence of, for instance, in the law, of moral defeaters, something like justifications in criminal law, entrenched fundamental rights in our Bill of Rights, and so on. It's possible that it's compatible or not compatible with this understanding of rule of law in normative legal positivism. Thank you.
Thank you, Jose Juan. Yes, I say in the paper that the value of source-based law, of laws satisfying the sources thesis is not absolute. It's only pro tanto. So it is desirable that the laws satisfy the sources thesis only to the extent that it is when and to the extent that it is reasonable that they do so. And explaining why this is not an empty qualification, an empty clause, would take us very far away from the topic of this paper. I think I would like, well, this is only wishful thinking, but I would like to formulate a version, to elaborate a version of normative legal positivism which leaves room for moral defeaters and principles, which only says that laws, claims that laws should satisfy the sources thesis when and to the extent that it is reasonable that they do so, leaving room for principles stating moral defeaters for rules. I would call this is, I repeat, wishful thinking, but I would call such a version of normative legal positivism, I would call it inclusive normative legal positivism, mimicking the idea that there is this kind of positivism, it's a normative idea, mimicking the claim that this kind of normative legal positivism incorporates part of our moral standards. But I'm not in a position, I'm not able, I do not know how to work out in a satisfactory way this position now. Thank you.
Thank you. Our next question comes from the front here and then here. So here first. Thank you.
Thank you. This is only a small comment to an otherwise excellent paper. You seem to downplay the role of coordination as such. And this is a common tendency, I think, both in legal theory and political theory, is to focus the drama of the hard cases in courts or the political drama of big issues in parliaments. And then we tend to forget that the enormous mass of norms and the enormous mass of decisions made in parliaments and other political organs is actually rather trivial and technical and means simply to guide our everyday life in some reasonable way, and the level of conflict of interests or conceptions of good is actually very low. So I have no systematic data, but to take just the parliament of my home country, so people don't usually know that 90% of all decisions are made unanimously. I think it's approximately the same in other parliaments. So it's not just conflict. There is an important need to coordinate our everyday activities by having relatively clear and stable rules. And the big issue of legitimacy does not usually come to play. We just have to deal with each other. I think this is an important aspect in law.
Thank you for this question too. This question too gives me the opportunity of stating something which, alas, is explicitly said in the paper, namely that what I mean when I say that coordination the law's role in affording the solution of coordination problems in the strict sense, when I say that this role of the law is of very limited import, is not what I mean when I say this is not that such cases, this kind of problems are rare, that they do not often occur. What I mean is a point made originally, I think, by Leslie Green a couple of days, about 15 years ago. What I mean is that in affording the solution to these kind of problems, in fact, the law works as a mere indicator. Law's claim to authority has no role to play in solving coordination problems like this, because by definition, in coordination problems proper, the parties are almost indifferent to which equilibrium is selected, so that it only suffices that an agency, whatever, indicates one equilibrium, so that for that equilibrium, it only suffices that an agency, whatever, indicates one equilibrium in order for that equilibrium to become salient in the eyes of the parties. And the parties will, by hypothesis, converge on it because they have no interest at all in not following suit when the others do the act as the equilibrium dictates. So, thank you.
Thank you. And the next question is down here on the left. Thank you.
In your presentation, you mentioned the possibility of abusing of a prescription model. You said, could you tell us something about that? What is, according to you, the dark side of an exercise of power through prescriptions?
No, sorry. Could you please repeat the question?
In a certain passage, you said, okay, there is the prescription model of exercise of power, which has this neutrality value inbuilt. But also you mentioned that it may be abused somehow. I'm curious about that. What do you have in mind as an abuse which may cancel this neutrality value, perhaps? But, thanks.
Yes, okay. Well, when I think about abuses of prescription, the institution of prescribing, I think of them on the model of abuses of the institution of assertion or promises in speech acts theory. So, for instance, insincere assertions are an abuse of the institution of asserting, and correspondingly, for instance, insincere prescriptions will be abuses of the institution of prescribing. Now, in what sense insincere prescriptions? One assumption which is constitutive of the practice of prescribing is the assumption that the lawgiver wants the addressee to perform the prescribed action. Now, this is only a defeasible assumption, of course, but we wouldn't understand what prescribing is, and we wouldn't be capable of finding our way in the issuing and receiving of prescriptions if we didn't postulate, presume that the lawgivers want their addressee
perform the action. An insincere prescription would be a prescription such that the lawgiver, in fact, doesn't want the addressee perform the action. He only, this is a possibility that, for instance, Elizabeth Anscombe mentions in intention. The possibility that the lawgiver merely wants to embarrass or put the addressee into trouble. Now, explicitly denying by the lawgiver that he wants the addressee perform the action would issue in an odd, unhappy, in the sense of the speech acts theory, unhappy prescription. Close the door, but I don't care whether you do it or not. This is a strange, this would be an odd prescription. But it is possible that, in fact, the lawgiver insincerely issues a prescription. In fact, and this is something which is explicitly, which is a phenomenon which is analyzed in one of the footnotes of my paper. In fact, it is possible to acquire a strong power over persons, on human beings, by issuing prescriptions that we know they will not be capable of complying with. So setting a standard, a very high standard for me. This is a good power of acquiring people, a good way of acquiring power over people because in this way we can induce them a strong feeling of guilt. And if we are capable, if we manage to set ourselves as persons who can, as the authorized forgivers for their guilts, for their faults, we can have and exercise a lot of power on them by abusing of the institution of prescribing. Thank you.
Thank you. We have 3 people left on the queue, which I think we should be able to get through, and then perhaps we'll see where we are time-wise. So the next question comes from the second row, from the front, on my right.
Diana Constantinescu, University College London. Professor Celano, thank you very much for such a solid and consistent paper, first of all. Second of all, I have just 2 small questions. First one is related to the concept of respect that you're using. I actually think that it is a strength of your paper that your theory applies not only to democratic societies, but maybe to other kinds of societies. On the other hand, you use respect, if you want, on a vertical dimension, from the lawgiver to addressee. And I was wondering what you think if the concept of respect would change its nature once it is applied in a democratic society, given that in that case, perhaps the lawgiver is merely a representative of the addressees. And the second question is regarding legitimacy. It seems that the Enlightenment rule of law doesn't need any kind of recourse to legitimacy. Of course, the gunman is not a legitimate representative of anyone. And I'm wondering if you already think that legitimacy is included in the sources thesis, or if you see it as any other connection. Thank you.
Yes. So, thank you. About the latter question, no, I do not think that legitimacy is included in the sources thesis. And, well, I agree, my concept of the rule of law does not. It depends on what you mean by legitimacy. but my concept of the rule of law or of enlightenment rule of law does not rely on the idea of legitimacy. Yes, no, it doesn't. I would say this. As far as the first question is concerned, whether respect, the notion of respect would be different in a democratic society, well, in a sense, no. It would. I would just say that in a democratic society there would be more respect for persons than there is according to mere enlightenment rule of law requirements. But if you adopt a strongly Quinian view about concepts and their changing according to the web of beliefs and assumptions we adopt in which they are placed, yes, maybe we could say that respect in a democratic society would be something different from the minimum of respect which is involved in merely prescribing something to somebody. Thank you.
Thank you. So next we have, I'm sorry, I don't know your name, as you can see, I don't really know anyone's name, but it's the gentleman to the left of Professor Wolochow in the red t-shirt. Sort of in the middle of the floor.
Okay.
I'll get him to, yeah. Could you stand up, please?
Right.
Thank you.
Peter Northup, New York University Politics. I also want to thank you for the very interesting paper and push you a little bit on the connection of the sources of your normative sources thesis, in particular to these rule of law neutrality values of stabilizing expectations and having this kind of...
excuse me, could you please speak a little bit more slowly, because otherwise I simply do not understand. I'm sorry.
So I wanted to press you a little bit on the contribution of the sources thesis to these rule of law neutrality values. And I want to do that by emphasizing the way that law has to address multiple audiences simultaneously. I think that to the extent that laws are addressing official audiences, administrators, judges, lawyers, addressing people like perhaps this room who are very highly educated in manipulating abstract normative systems, then it's quite right then it seems quite plausible to me that restricting the grounds of judgment to authoritative written public documents does indeed stabilize expectations and have this sort of communicative respect that you indicate. However, when we're also addressing these normative commands to people who may have secondary education or not even that, but are embedded within their own systems of understanding of fair conduct and what have you, telling a farmer or factory worker with dropped out of high school that their contractual dealings should be, the grounds of their dealings should be restricted to the norms embodied in a 500-page code may not be experienced as stabilizing expectations or kind of a communication that presupposes agency, but almost a hostile act, a sort of displacing of fairly well understood standards of fairness and right dealing with something that's not easy to understand at all and not at all navigable. And so I wonder, something that seems to reject the sources thesis might even be better for those particular rule of law values, such as, say, an injunction that contractual dealings be fair and that their fairness be judged by a jury of similarly situated people. And then those judgments would explicitly not then be restricted to authoritative written standards. But yet that seems to, in some circumstances, quite possibly do better at these desiderata. And that seems an empirical rather than a conceptual question. So I guess I'm just wondering whether these, the claims you're making are ones that are sort of restricted to administrators and judges, or whether you would extend them also to kind of final end users of the law. Thank you.
Thank you very much. You're right in most, I think you're right in most of what you've said. The model I presented, the idea I presented, the model I presented is meant to involve all members of the political community in the communication situation which prescribing is. So everybody should be addressed by prescriptions, and prescriptions according to Enlightenment rule of law should be addressed to everybody in the political community. But obviously this is, as I said, a very simplistic idea, and it's utopian and simplistic idea, which is perhaps tied in too strong a way to very naive assumptions of people of the 18th century, of the Enlightenment. And I have in fact, no answer for this. I think it is a matter of degree, of course. To some extent, perhaps, this kind of idea could be realized. To some extent, it has been realized since the 18th century up to our days, but obviously it cannot be entirely realized, and it certainly is to some extent simplistic and naive. Thank you.
Thank you. We've actually reached the end of the queue now. We probably have time for a further question, if there is one. Scratching your head at this stage is dangerous because I may... okay. At the back of the room, we have Stefan. Right at the back. Thank you.
Thanks for the paper. I had a question that wants to explore the relationship between, say, Rawls's, maybe we call it a descriptive or an ontological sources thesis, and your normative sources thesis. And I want to start with a metaphor. And the metaphor would be, so Kant has this idea that angels aren't subject to duties. And the reason they're not subject to duties is because, given the way that they are, they're just built in a way that they're going to act in accordance with the moral law. They just have one source of motivation. So I wonder if your normative legal positivism actually presupposes, in a way, in an interesting way, the falsity of Rawls's exclusive legal positivism. The idea would be that perhaps by, just the way things are, the law just is something that can only be identified by, virtue of its source. And that, if that were the case, perhaps that would give the normative legal positivist thesis nothing to do. Thanks.
Thank you. Well, the normative sources thesis presupposes that the law can satisfy the sources thesis. can be source-based. But does it also presuppose that it is possible that the law does not satisfy the sources? Thesis does not stem from sources. So in other words, does the normative sources thesis presuppose the truth of Rase's sources thesis, or does it presuppose its falsity? So yes, this is the question. There is a very sketchy discussion on precisely this question in the paper. I distinguish two versions of normative legal positivism. One I call Panglossian, a Panglossian version, a version to which it is desirable that the law satisfies the normative sources thesis, but it is also true that it satisfies, and necessarily true that it satisfies Rase's sources thesis. So this is the position of positivity welcomers, people who say, well, the law satisfies Rase's sources thesis, and it's a very good thing that it is so. On the other hand, there is a second version, distinguish a second version of normative legal positivism, which I call the contingency version, according to which it is contingent whether the law satisfies or not Rase's sources thesis. Now this leaves us with the obvious problem of explaining how could the law not satisfy Rase's sources thesis. The obvious answer for positivists, the obvious hypothesis for positivists would be to think of incorporation of morality by law. And this would grant us a way of defending, of understanding the contingency version of normative legal positivism. On the other hand, I think that the position, Rase's position, as stated in his paper Incorporation by Law, would also allow for a defense, enable us to defend the normative sources thesis, because it is, we could say that it is contingent whether the law satisfies Rase's sources thesis in the sense and to the extent that the law may, to the extent that what appears as incorporation of morality, apparent cases of incorporation of morality by law, are in fact cases of non-exclusion of morality by law, or cases of modulation of the application of morality, modulation by law of the application of morality. This is enough, I would say, for the contingency version of normative legal positivism, as I understand. So I would like to remain agnostic about whether Rase's sources thesis is true or not. And I would like to think that it is possible to defend a contingency, the contingency version of normative legal positivism, so of the normative sources thesis, while remaining agnostic on this point. Thank you.
Many thanks. In drawing the debate to a close, I'd like to thank the audience for their thoughtful and stimulating questions, and I'd like to invite the audience to join with me in thanking Professor Celano for his rich, subtle, wonderful paper.